I am Tanindra Sivarajan. Duty of care is a legal responsibility to act a reasonable person and avoid causing harm to others. So the harm must be reasonable, foreseeable, and there must be a close relationship known as proximity. So it ensures that individuals are held accountable for careless actions. So negligent misstatement occurs when a person carelessly gives false or inaccurate information which is relied upon by another person, leading to financial loss. So it usually arises where there is a special relationship involving trust or expertise. So it protects people from suffering loss due to unreliable advice.
So I'm Harini. So today I'm going to explain about the process and elements. The process of establishing duty of care begins with neighbor principle from Donner versus Stevenson, which state that a person must take reasonable care to avoid acts or omission that could forcibly harm others closely affected by their actions. The court checked if the harm was forcible and whether there was proximity between the parties. Then the law developed through the ANS 2-stage test, which comes from the ANS versus Merton London Law Council. Stage 1 examines the forcibility and proximity to establish prima facie duty of care. Stage 2 consider policy factors like avoiding unlimited liability and protecting public interest, which may limit or reduce the duty. The modern approach is Caparo 3-stage test, which is first forcibility, second is proximity, and lastly is fair, just, or reasonable. Finally, forcibility is a key. Defendant is liable only if a reasonable person could predict the harm. If the harm is too remote or unlikely, the duty arises as shown in both cases. Now I'll explain about the elements of negligent misstatement. First, there must be a special relationship where one party relies on another expertise. Second, there must be assumption of responsibility, meaning the defendant knows the statement will be relied on. Third, there must be reliance where the claimant actually acts on the statement. Fourth, the reliance must be reasonable, not careless or blind. Fifth, there must be economic loss, meaning financial loss. In addition, the claimant must prove duty of care or breach of duty. These elements ensure only valid claims succeed. Thank you.
Hi, my name is Tarifa. So, a special or fiduciary relationship exists when one party relies on the skill or expertise, creating a relationship of trust and confidence. For example, Esso and Petroleum Martin claimant are dependent on company advice about the project profit, which established a duty of care because of the reliance on professional expertise. Voluntary assumption of responsibilities occur when a person knowingly accepts responsibilities for the advice or statement they give. In Hadley, Bryan and Co., and also partner at the bank of provide a reference creating a duty but liability divided because of the disclaimer was included. This shows the responsibility must be accepted and a clear liability of arise. Lastly is reasonable reliance, means that a claimant must be actually act on the statement and their reliance must be justified and logical, not careless or blind. In Capara Industries and Dickman, the court examined whether the investor reliance on the accrual was reasonable, and finally the liability was not arise if it was proper and could not expected in the circumstances. Thank you.
I'll present some examples. For duty of care, a driver who runs a red light owes a duty to other road users to drive safely. For negligent misstatement, a financial advisor who gives incorrect advice without a paper checking may liable for the financial loss.
Today I'm Vaishnav Viswanathan. I'll be presenting the case laws. The first case law is Donaghy versus Stevenson case. So in this case, a woman became ill after drinking a ginger beer that contained a snail. So the court held that the manufacturer owed the duty of care because the harm was reasonably foreseeable. This case established the neighbor's principle also, which forms the foundation of negligence law. Next case is Hadley versus Heller. Here the claimant relied on a bank statement and suffered financial loss. The court recognized that a duty of care arises for negligence misstatements when there is a legal relationship and reliance. However, there was no liability in this case because the bank included a disclaimer. So moving on to the next case, Caparo versus Dickman. The claimant relied on audited account to make an investment and suffered loss. So the court held that the duty of care was owed due to lack of proximity and because it was not fair. And it was not reasonable as well. This case introduced Caparo stage 3 test, which is used to determine duty of care today. Thank you. In conclusion, these cases are very important in order to show negligence for these cases. Thank you.